Before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yes, I understand.
All right. The docket before you, Your Honor, is 2019-846DS in the matter of Ms. Kelly Bridges versus Mr. Derek Wagner, with Mr. Wagner being the payer. This is an adjourned enforcement hearing. It was adjourned to allow him to be represented by court-appointed attorney as requested. It was originally, prior to that adjournment, a bench warrant hearing for his failure to appear at a referee hearing on June 13th of 2022. The order being enforced today is the modified uniform child support order dated January 13th of 2020, which states that his current child support is $109. After servicing and processing fees, brings it to $112.50. His last payment was $148.28 on September 3rd of 2021 via unemployment. He has been show cause 3 times with 1 bench warrant and 1 finding of contempt. The previous 6 months at $112.50, he should have paid $675, and he has paid.
Right from the intro, the tone is set. This isn't just a routine hearing. It's a slow-burning disaster. The judge clearly explains the stakes, the possible jail time, and confirms understanding. This moment matters because it shows the court doing everything by the book. No tricks, no confusion, just clear expectations. When chaos later unfolds, remember this part. Everyone was warned, everyone was informed, and everyone had a fair chance to keep things calm.
$4,747.94. There have been no previous jail sentences with that previous contempt hearing. Mr. Wagner was booked in on March 3rd in the Calhoun County Jail on separate charges. When he was booked in on our warrant, he was in jail from February 16th to February 23rd.
Okay, do you have any questions for Ms. Wills?
Yes. Ms. Wills, has he been in jail since February 16th?
No, so he was in jail February 16th to February 23rd. He bonded out on the 23rd, and then he was booked back into jail on March 3rd. And he's been there since March 3rd on separate charges that are not FOC related.
And does he qualify for the LEAP program?
Nope.
No, so with Mr. Wagner, let me make sure that we have his correct address on file. The previous address, he does qualify for LEAP. However, due to, us not being able to get in contact with him and having the bench warrant for so long, he did not qualify. He does now, as long as he doesn't have any other warrants in the state of Michigan.
Okay, thank you. No further questions.
Okay. Any proofs, Mr. Sackrader?
Yes, I'd call Mr. Wagner.
Okay, go ahead.
All right, Mr. Wagner, can you hear me?
Yes.
You heard the testimony of Ms. Wills, is that correct?
Yes.
Is there anything that you disagreed with?
No, sir.
Okay. So you were booked in, looks like February 16th, and then you bonded out on February 23rd by posting a $100 bond, is that correct?
Correct.
Are you willing to put that bond amount towards your child support arrearages?
The enforcement officer methodically lays out dates, numbers, missed payments, and prior chances. This is an opinion. It's a timeline backed by records. The strength of this section is its simplicity. Facts don't need volume or emotion. While interruptions start creeping in, the record speaks loudly on its own. This is how cases are built, steady, unemotional, and detailed. Everything that follows is stacked on this foundation.
Mr. Wagner, not from you at this time. You'll have an opportunity to speak after that, so please don't interrupt.
Okay. All right. Ms. Wills testified that you're being held on other criminal charges in the jail. Is that correct?
Yes, sir.
Do you have a hearing date or a release date for those other charges?
I have a release date on the 8th.
On April 8th,
Yes, sir.
you're expected to be released.
Yes.
Okay. Prior to February 16th of 2023, were you employed?
No.
Lie.
Hold
Okay.
on a second. Just hold on. Ms. Bridges, was I unclear about not speaking or interrupting? Ma'am?
So what? Y'all can shake a piece of shit motherfucking hand and say
Hey,
congratulations.
ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
As the facts pile up, frustration spills over from the gallery. The outbursts don't help the case they're meant to support. Instead, they shift attention away from the evidence and toward behavior. Courts notice that immediately. This is a key lesson. Even when the facts are on your side, losing composure weakens your position. Silence here would have been powerful. Noise only creates new problems.
Meaning to the issue before the court, which is his non-payment of child support. Do you have any questions?
I already know why his non-payment of child support is. Why he's had a job the whole time working for Larson's Construction, making $26 an hour underneath the table for months now.
Okay,
Instead,
ma'am,
maybe-
this is your
in a
time
fucking
to ask him. This is your time to ask him questions, not for you to give a statement at this point. So if you have any questions for him, ask those.
okay, Derek, seeing you had money to buy alcohol, why were you not paying your child support?
I was terminated because you had contacted FOC before I had a chance to be placed on payroll, so I was terminated.
That's not my fault. You know you're supposed to pay child support. Pay your shit. Be a man.
Questions focus on jail time, bonds, and eligibility for assistance programs. This section shows the court actively checking whether alternatives exist and whether the system gave opportunities. Nothing is rushed. The judge isn't hunting for punishment. He's verifying circumstances. This matters because later claims of unfairness fall flat when the record shows careful consideration at every step.
Has a minimal support obligation of $148.50 per month, including his arrearage repayment in this matter. That, in fact, over the last year, he has, as he stated, he's worked approximately 2.5 months during that time, making $200 per week. On each of those weeks, that he acknowledges that he simply failed to pay, and there's no excuse for not doing so. In addition to that, he did have odd jobs. He stated that he has been hindered somewhat because he has not had an ID or a birth certificate, etc., to acquire employment, but he has not stated any effort he's made to acquire that. Likewise with the GED, other than that he's had no money to do that. The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. Anything before sentencing, Mr. Sackrader?
Yes, thank you, Your Honor. My client testified that he will be on probation upon his release and his other criminal matters.
When Mr. Wagner confirms the testimony and admits no disagreement with the facts, the case tightens instantly. Admissions carry weight. The question about applying bond money toward support is practical and reasonable. It shows the court trying to redirect resources toward responsibility instead of conflict. This was a chance for things to de-escalate. Instead, outside commentary derails it.
Obligation, we would ask that any jail sentence be 31 days or less, with credit for 7 days already served in this matter. We would request a purge amount in the amount of $400. Thank you, Your Honor.
Thank you. Well, in this matter, Mr. Wagner, I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time, even though you did have a prior contempt. There was no jail time at that point. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served, and I'm going to put a purge amount in place of the amount of $500. If you're able to pay the purge amount, then you would not have to serve the balance of your jail sentence. Do you have any questions, sir?
No, Your Honor.
Okay. Court will end this matter at 11 a.m. You're free to go. Have a good day.
That's bullshit. You guys shake his hand and tell him congratulations.
Now, the case is...
Repeated interruptions force the judge to draw a firm line. The warning is clear, direct, and calm. Courts run on order, not commentary from the sidelines. This moment is crucial because it shows restraint from the bench. Many judges would have acted sooner. Instead, patience is extended, one more chance to correct behavior before consequences follow.